So thank you for the very kind introduction. My name is Michael Huertas. I'm a partner with PwC Legal, which is the full-service law firm of PwC. I head up the financial services practice. We're 450 financial services lawyers in 100 countries. Today, I'm speaking to you with my PwC hat half off, if you allow me to, because first of all, the obvious disclaimer, nothing that I'm going to talk about today is legal advice. We're happy to put my PwC hat back on and we can talk about some of the legal specifics. But I'm also going to be a little bit critical about some of the views in the market, if that's okay with you. And I appreciate we probably have some Q&A time planned in. I've done the unfortunate bad lawyer thing and probably overloaded the slides somewhat. Don't worry, we're not doing death by PowerPoint, because otherwise I would have already exhausted 5 slides by now. So what I would like to talk about today, and if I can I share that part there? What I'm going to talk about today is very much briefly why MiCA is a great thing from a legal perspective, regulatory perspective, recap on some of the token classification aspects under MiCA, then dive into asset reference tokens, because that's where MiCA starts, even though in terms of when it sets out the legal obligations, and particularly I'd like to focus on recovery plans and redemption plans, because that's, to Christos's point, that's where MiCA has borrowed somewhat from the traditional banking financial services regulation approach, but there's some problems there as well. And then I'm going to switch to e-money tokens, which are the real stable coins, if you want, in terms of fiat-linked currency stable coins, and then talk about some of the key considerations and challenges ahead. Christos has already, in his concluding remarks before the break, kindly pointed out that all the regulators are going to be getting along with one another. I think from my former brief time at the ECB, and hopefully Martin will probably agree with me, regulators are people. Not everyone always gets along with one another. So one of the issues, of course, is that what might be great on paper, and perfect on paper, may be a little bit poor in practice or could run into difficulties. So that just to sort of think about as we go through this. Okay, thankfully these slides are large enough in the room. They're very small on here. Where are we with MiCA? So MiCA, we have to remind ourselves that MiCA is a pan-EU 27 regulation that really expands the single rulebook of financial services to crypto assets. Not all crypto assets are included in MiCA 1.0, where we currently stand. Some of the aspects we touched upon briefly earlier about decentralization versus centralization, some question marks around non-fungible tokens, when it's included, when it's not included. But MiCA really is a game changer in international financial services regulation, because it's for the first time in the world that we have truly a single rule book for crypto assets, and in record time. From a legislative process perspective, the EU has actually, it doesn't matter where you stand in terms of pro-EU, I'm obviously very pro-EU, very federalist EU, as a further disclaimer to my statements. But the key issue is that it was done in record time. And because it was done in record time, a lot of the devil is in the detail when it comes to further rulemaking that is in regulated technical standards or also in implementing technical standards which are on their way, certain of them which need to be finalized before 30th of June, certain of them which need to be finalized before 30th of December of this year, and then others which cascade through as we move to full online MiCA compliance, if you want, or full enforce of MiCA. So regulation is a journey. Regulation is also an ability to set a standard that certainly other jurisdictions are potentially looking at. So MiCA, yes, it's been done in record time. Yes, there's further detail that's required. But in terms of a regulatory gold standard, it's very much MiCA at the forefront, and other jurisdictions are looking either to emulate or to see how you can potentially have some form of equivalence in the future, which MiCA unfortunately doesn't have equivalence provisions in it. But that's not to say that a non-EU country could potentially say, if you're regulated by MiCA, you might find it easier to be regulated in my jurisdiction without any additional obligations on top of that. So that's just to think about how we frame MiCA in a global context. In particular, when it comes to stable coins, right? MiCA's emphasis from the very first instance, I think, was when LibraCoin, or the Diem project from Mark Zuckerberg and friends at Meta, announced they were going to introduce a stablecoin. And from that point, I think it's pretty common knowledge now, the light bulb went on the legislative and regulatory policymakers to say, we need to figure out what to do with crypto assets. Because each member state was doing their own thing, and each member state was approaching it generally, if it looks like a security, I'll treat it like a security, but what do I do with all this stuff that's digitizing, tokenizing fiat currency, or tokenizing gold? How do I look at that? And Diem actually put the step forward and said, okay, we need to have a regime on stablecoins. So what do we have, just to recap? We split the MiCA universe between tokens, digital assets that are MiCA regulated, and a much longer list that are, of course, regulated under MiFID, IFR, IFD as well, of course, but effectively are a much longer list where a number of use cases currently in the market could potentially fall somewhere in the middle between MiCA and financial instruments, and if there's some semblance that it could fall onto the traditional financial instrument side of things, it very much moves over to the traditional financial services regulatory environment. Okay, and that has a number of implications when it comes to how you set up target operating models for crypto asset firms, who not only have to comply with MiCA, but also have to comply with MiFID, or one regulation is in the driving seat on that. Where there is, of course, great certainty on MiCA, and very much that MiCA is in the lead on regulation, is with respect to asset reference tokens and e-money tokens, so commonly known as stablecoins. Asset reference tokens are effectively, can reference multiple assets, and e-money tokens can reference one fiat currency. That's the easiest way to think of it. That definition is set out in MiCA itself. It is conceivable that over time, as the current RTS that are out for finalization on where do crypto assets fall into, do they fall into the traditional financial services world, or do they fall into the crypto asset MiCA-led world, that there will be further guidance on that, because that's currently one of the RTS that is still out for finalization. If we look through, MiCA overall is drafted in a way that it is designed to be, regardless of what certain policymakers tell you, it is designed to be an evolutionary legislation. It's all-encompassing, but it is designed very much that you have MiCA 1.0 where we currently stand, and at some certain time in the future, we will have MiCA 2.0. And we will have further rulemaking through RTS, ITS, and we'll have further rulemaking through supervisory expectations, and also policy from either the European supervisory authorities under the mandates that they have under MiCA, or also national competent authorities when things happen. That's just the natural aspect of it. And if you look at MiCA, and one of the things, if you permit me, when I was at a certain central bank in Frankfurt with a European reach, one of the things that someone said to me, said, if you want to make rules in Europe, pack it into the recitals. It allows you a lot of flexibility. No one reads the recitals anyway, and it allows you for a lot of operational aspects, right? There are some aspects in the recitals which do look, and there are also some aspects in the report requirements, which I'll come to in a moment, that do set out some of the future potential rulemaking clarifications. So very quickly then also, when we look at how we look at stablecoins under the MiCA regime, the most important thing I think to focus on, I'm not sure whether I can show this on screen, if you can see the mouse moving? Can I? Okay, so the bottom left box, effectively, where we have ARTs and EMTs. We have rules that apply to ARTs and EMTs, but we also have additional rules that apply to significant ARTs and EMTs. It's very conceivable that a lot of the stablecoin offerings that are in the market currently are very likely to fall under the significant bucket, which means that they become automatically subject to more stringent regulation, and they also become subject to more invasive supervisory scrutiny. And for a number of market operators at the moment that are looking at becoming a stablecoin issuer and having an ART, EMT regulated footprint, as well as an e-money license to do that, becoming a significant ART, EMT issuer is of course something that they're aiming for. But as these new rules, which apply from 30th of June, come online, presumably through at least probably 12 to 18 months, where there is some degree of supervisory flexibility. As we get to the end of those 12 to 18 months, some of that flexibility will fall away, and the new reality is certainly much more stringent. The other thing also to bear in mind, that a stable coin, whilst it may be linked, if we, for example, take a euro-linked stable coin, a euro-linked EMT, if we compare that to a CBDC, so the digital euro, a euro-linked stablecoin would mean, or euro-linked EMT would mean that one euro EMT equals one physical euro. The same concept, of course, with the CBDC. There are very different features, of course, between a CBDC and a stablecoin and how they're regulated. First of all, CBDCs are not regulated by MiCA. They're completely taken outside the scope of MiCA. There are other restrictions that apply in terms of CBDCs, how much you can hold, where you can hold it, and so on and so forth. And one of the key sort of changes for the market as a whole, from everyone from a retail investor through to wholesale market participants, is to actually weigh up, yes, it's great that we have MiCA that provides the comfort that we have greater rules, but each of the stable coins, EMTs, ARTs, may have differing features. And secondly, a euro EMT will also have very differing features in a practical use case scenario to a CBDC. So from a market perspective, a lot of the complications that also exist in not only transitioning to the new regulatory reality of MiCA is also to focus on how do I actually educate my clients, whether wholesale market participant counterparties through to retail clients and end users, just exactly what's on offer. And there's a lot of there's a lot of education that still needs to be done on that, where there's a lot of pressure to do that. So just very briefly again, the demarcation between ART and EMT, e-money tokens must be backed only and at least one fiat currency, which is legal tender, right? While ARTs may reference a broader class of assets, including one or more fiat currencies. At present, most of the ARTs that are out there in the market are not as complicated as referencing multiple fiat currencies. Most of the ARTs that are out there currently in development that have a real prospect of being used in a valuable manner. Of course, every token is valuable depending on how much value it attracts, but in a valuable manner in terms of market uptake, are linked to commodities. So you may have seen recently HSBC is launching a gold-backed token. They're launching it outside the scope of MiCA. It's a question as to why HSBC is doing that. That's probably more I wouldn't say it's any sort of negative aspect vis-a-vis MiCA. There's some other reasons for that, more economic reasons, but it's mostly commodity-linked tokens. The key issue is that the definitions that exist in the MiCA Level 1 text still probably need some further clarifications as you have further stablecoin use cases where the question becomes, am I an ART or an EMT to begin with, or am I potentially a tokenized financial instrument that falls in the traditional financial services space? That's the first main question that is always relevant. And then the second question is really to understand, do I fall under an ART or do I fall under an EMT? If I fall under an EMT, well, it's usually quite easy to understand, do I fall under an EMT? It sometimes becomes more difficult when I have multi-currency, in theory, multi-currency ARTs, and then I change the features in the token. Because of course I have a lot of flexibility, as we saw from Josh's presentation. It's very, if you can quickly program it, you can quickly participate in the market. Obviously it takes a little bit longer to get a license, but it's important to sort of think about how products can evolve and how they will be treated under MiCA. And there's still some further work needed there from policymakers. Very briefly again, the other way that I think is important to distinguish between ARTs and EMTs is their use cases. Both can be used for transactions, both can be used for payments, of course. If one can accept it, one can use it for payment. There is, however, sort of more an implied aspect that there could be an underlying investment use case for ARTs. So if we go back to the gold-based example, if an ART is linked to the gold price and has to remain stable with that gold price, holding ART will potentially, the value will increase in the price as the value of gold increases, right? You don't have that when you have a euro-linked EMT. You can have effectively currency fluctuations. If you hold a euro EMT and you'd like to exchange it to US dollar in fiat currency or US dollar stablecoin, but you don't have an implied investment uplift. With an ART linked to a commodity, you have that. One of the things that's quite common, of course, or is actually, it's common because it's regulated, is that you cannot, stablecoins don't attract interest. CBDCs don't attract interest. In Germany, where the criticisms about not getting interest have, of course, dominated a number of legal proceedings at various different levels. This all, of course, is something which bears the question, if I'm holding from a retail client perspective, it bears the question, why would I bother to hold an asset reference token or an e-money token that doesn't attract interest if I can just hold euros in a bank where the bank will pay me interest and effectively I have depositor protection? It's a very valid question. I think that is part of the education aspect. The counterbalance to it, of course, is that stablecoins allow me for potentially a lot greater efficiency, even for a retail client perspective, to effect payments in a faster manner, or potentially in a faster manner where there's also outside of SEPA and outside of effectively the existing payment infrastructure that we have in the European Union or in the Euro area, in the SEPA area, of course, that we take for granted, that we can have everything from faster payments through to settlement in central bank-based money, right? You can do that with the CBDC as well. But the question is really, what's the actual implied use case for a retail client in using a stablecoin, right? And that's where that education piece comes back in. From a wholesale market participant perspective, the use case is very clear. I can affect greater efficiency in payments if I am operating in certain jurisdictions where I may have capital controls or currency controls. I can effectively create even a private stablecoin to run my treasury operations on, as opposed to having to use traditional means that could be subject to complications. And the use cases there are infinite. Now, the issue is that MiCA doesn't think of those use cases. MiCA sets the definition of, do you fall into that bucket of either a stablecoin or a non-stablecoin MiCA regulated instrument, or do you fall under the traditional financial services bucket and be lead regulated under those rules? So there is still some aspects to be clarified for a number of potential users of stablecoins, where understanding the details of the regulations are important. That becomes ever more important when we start to look at significance criteria in respect of if a asset reference token is deemed significant, and also if an EMT is deemed significant by the European Banking Authority, then effectively the way that issuer of AMT, of the ART or the EMT are regulated changes. And so it's quite easy, if you think about it in principle, to fall into at least 3 out of the following significance criteria. So the significance criteria, if we look at some of the less quantitative and more the qualitative based criteria, that can apply quite quickly, right? So there is a commercial decision that, of course, applies to anyone who's looking to enter the stablecoin space to figure out, do I go head straight into the reality that I'm going to become a significant asset reference token issuer or EMT issuer from the outset, and should I prepare compliance in the scenario in mind that I will be supervised in full? Or should I just prepare to do the basic minimum? Now, as a more conservative lawyer, I would say prepare for the worst and hope for the best. Unfortunately, a lot of market participants are preparing for the bare minimum, and that's part of the problem as we move to the 30th of June, where it's a rush to that day one compliance, or at least sort of maybe 80% day one compliance, and that hope of supervisory flexibility for a 12 to 18 month period in order to get to at least that 100% day one compliance and move to sort of a 150% enthusiasm level for a day 30, day 90, day 365 compliance level. So this is some of the aspects that I think are quite important to understand, just where the market currently is in preparing for these rules. The other things that are, I think, should be familiar to most professionals, both market participants or those generally in this space, is that if you are a significant ART or EMT issuer, the additional rules that apply, a lot of them aim to, first of all, provide greater security in terms of what happens when things go wrong, and particularly some of the fallbacks that are put in there. So chief amongst that, of course, is if you're significant, you're going to have a larger amount of regulatory capital that you have put aside. And I'll come back to regulatory capital and reserve of assets in a moment. And the other aspect, of course, is a requirement to have multiple custodians as well, which is again, one of those things that is great on paper, not always so easy to do in practice, because you've got to, first of all, find the right custodians. You secondly have to document your agreement with them, and then you have to start worrying about concentration risk, that pretty much everyone in the market might be using the same custodian, and what happens with that type of aspect. The other thing, of course, liquidity management and liquidity stress testing should be familiar from the traditional banking space, and then effectively interoperability and porting of aspects. The real game changer, I think, in the MiCA debate came with also extending that now tried and tested recovery and resolution planning aspects when it comes to the banking space, and applying that to the crypto asset space and stablecoins. Specifically, a recovery plan is required only for, as it stands now, only for asset reference token issuers, but a redemption plan is required for both asset reference token issuers and e-money token issuers. So let's start with redemption plan first, because that's usually what will happen but prior to going into a recovery situation. But a redemption plan basically has to demonstrate to the regulators, certainly, and in a more bespoke, more compact version to the public, as to what happens in terms of redeeming the stablecoin when a competent authority, so either one of the ESAs or the NCAs, deems that issuer to be unable or likely to be unable to fulfill its obligations. So you'll probably think that sounds like failing or likely to fail from the banking world. It is. So I mean, it's the same concept, different trigger levels. Those trigger levels need to, of course, still be defined, and that's one of the things for the ESAs to do. But if we take the more pessimistic view that regulators will want market participants to prepare for the worst and hope for the best, drafting that trigger level in that plan is quite crucial to be able to get the regulator to sign off that the redemption plan passes their supervisory expectations. So once a trigger event happens, one has to then look at how do I actually carry out the redemption, and more importantly, that I don't cause harm to the market, or I don't cause harm to financial stability overall, including market counterparts in that market. Again, those are factors which, if you are familiar with and you'll forgive me for purposely putting that in those air quotations for sarcasm, because I do really mean it sarcastically, the helpful change to prudential regulatory requirements for investment firms that was introduced with the investment firm regulation, where you suddenly have, instead of saying your regulatory capital requirements if you do business XYZ is 50,000 euros or 75,000 euros or 150,000 euros and going upwards, that simplification brought into play the so-called K factors, which looks at risk to market, risk to counterparty, etc. Similar type of concept applies here. You have to look at what is the risk if I carry out a redemption to the people that I potentially am dealing with. Okay, so this is one of the aspects. Yes, again, it makes sense on paper, but there's going to potentially still be a lot of work to be done to put that into practice, to make sure that the redemption plans that are required actually fulfill supervisory expectations, where the definitions that have been put into the legislative requirements still allow for a great degree of interpretation, right? And sometimes it's wonderful to have interpretation when it comes to legislative requirements, and sometimes markets, and certainly even us as a community of lawyers, would potentially like to have greater legal certainty to understand what do I actually need to have in terms of making sure that I'm not causing harm when to a counterpart or to the market. What is actually the criteria? What is defined by harm? And the other aspect, of course, is to look at continuity of any critical activities. Again, that's something which comes from traditional financial services regulation and concepts that have been long established. However, we don't have a clear definition of what is a critical activity. It's not potentially a critical economic function, as we have in traditional financial services regulation. So again, we can see wonderful aspects, still a bit of degree in the market to get there for redemption plans. The same also applies to recovery plans. Recovery plans are, again, they borrow from aspects in the banking sector, but the trigger points for early regulatory intervention haven't yet been fully defined. And I think the first, and I would imagine there could always be a possibility that there will be a use of product intervention powers by EU authorities, so the ESAs, or also in conjunction with national competent authorities. But you don't want to necessarily be on the receiving end of a product intervention power being applied. So part of the aspects that firms need to consider when drawing up recovery plans and redemption plans is to look at clearly defining what the steps are in respect to respective triggers, and perhaps also erring on the side of caution. Very briefly then on EMTs. EMTs are, so classic example is US dollar stable coins, either USDC, USDT, Euro denominated stable coins, Euro C from Circle, for example, would be something that would fall under an EMT. They're designed effectively as a payment functionality. The clear requirement is that you can only offer an EMT or have an EMT admitted to a crypto asset trading platform if the issuer itself is authorized as an EMI, as an e-money institution under what is currently still the second e-money directive, or if you're a credit institution. And there are obviously that makes total sense, going also to the point that Josh was making earlier, that if we are in a new world where we place all of our trust when it comes to a relatively new regulated party, then we should hold them to the same standard as a credit institution or an EMD licensed authority, licensed firm. So the main aspect that I think is problematic on the horizon is that if you've been following the proposals to reform the second payment services directive, which will become PSD 3. So we'll move from PSD 2 to PSD 3. We will also get a payment services regulation, the PSR. The aims on, and apologies, this is going to be like acronym bingo in a moment, right? We have EMD2, right, which exists in conjunction with PSD2. EMD2, under the PSD2 upgrade to PSD3 and PSR, will stop to exist, and the provisions under EMD2 become part of PSR PSD3. I see a lot of stunned and worried faces. You're not alone. Every client in the market, or every market participant that's looking on becoming an EMI is thinking, okay, if I have to apply now under the current framework of EMD2, and under this upgrade that's happening under PSR PSD3, EMD2 ceases to apply, and anyone who has an e-money institution license has to reapply for that license. And there is no grandfathering principle as of yet. That's wonderful opportunity for lawyers to make a lot of money advising on license applications, which I will say, thank you very much, Brussels. Wonderful, but from a market efficiency perspective, a complete pain. So what do you need to do when you're faced with that situation? You need to basically start to look at what is the delta between the requirements that apply for a EMD2 license as supplemented by the requirements that apply for an EMT issuer as topped up for a significant EMT issuer. What differences do I have to an ART or a significant ART? Then take a step back, breathe, have a cup of coffee, and then figure out what do I need to put on top to make clear that I am able to meet PSR requirements that will possibly come in by 2026. And that's the current state of play that we have with EMTs. The other option is become a bank, become a credit institution license. And pretty much any stablecoin issuer out there is not, anyone who is not yet a regulated firm is probably put off by that until they call some of the lawyers that help them find the right way, which of course brings me back to the point, thank you, Brussels. But the issue is that unless this is resolved, and this is where we're going back to the point of MiCA 1.0 did a lot, and it's a lot of good things that it's done. But unless that's resolved, MiCA 2.0, unless MiCA 2.0 can resolve all of this, a lot of the stablecoin aspects may no longer be as attractive within the European Union. And to a point that we were having outside shortly before this session, even if an EMT is then effectively deregistered from a European exchange, what power does a regulator have to come into a private individual who has bought a stable coin and holds that stable coin outside of the European Union? And that's a whole area where we have aspects of financial services regulation trying to protect consumers, infringing potentially on private rights and privity of contract. So again, there's a lot in there. And since I'm up against the clock, I will just very quickly summarize a couple of the next steps before we jump into some of the other considerations and challenges. So very briefly here, in terms of EMT rules, a lot of it is a variation of asset reference token rules, just to simplify that. There are certain small aspects which apply in addition to the ART rules as applied to EMT rules. Principal amongst that would be to look at white paper requirements for EMTs, which are somewhat different than asset reference tokens, and some additional requirements that are set out there, as well as overall disclosure aspects that need to be reflected in communications with clients and clients of that EMT issuer, and also in respect to admission to trading. So there's a couple of aspects that are there. The other aspect is in terms of when the EBA can get involved. If you're significant, the EBA will get involved. However, the EBA can also get involved for non-euro currencies of an EU member state. At present, there are, at least to the best of my knowledge, there are no non-euro stable coins. So there's the e-kroner in theory, but that's a CBDC. But there's no, for example, private Swedish kroner stablecoin. There's no private Czech crown stablecoin or Hungarian forint stablecoin. So the EBA's main concentration will be on euro area stablecoins until that changes. But there is that concept there, and I think it's a sensible one, and it's one where giving the European supervisory authorities the power to be in the driving seat on supervising significant asset reference token issuers and significant e-money token issuers is important. Part of the issue then becomes how the EBA engages and cooperates with the national competent authorities, and how they get into the running order of doing that. Because, as Christos has said, there are specific provisions in MiCA that set out who is to do what with respect to whom and when. But those authorities, regulators are people, they need to be able to get along with one another. That needs to happen in a relatively quick fashion over the period from 30th of June onwards. So that brings me to some of the key considerations and challenges. We've touched upon a lot of this in terms of these moves between a pre-MiCA to MiCA, effectively requiring new licenses. Some of the challenges it applies to existing e-money issuers, and in terms of upgrading their own existing license, and what that means for potential future e-money token issuers. And then we've also touched upon certainly the cooperation and respective who regulates whom, when, and how issues that are set out in Articles 93 to 108 of MiCA. The key point is that Christos said it's not going to be like banking union. I'm not going to use up the rest of my time to challenge him on that, but I do think that some of the lessons learned from banking union probably need to be applied. How regulators will cooperate with asset reference token issuers, e-money token issuers, but overall crypto asset service providers that fall under MiCA as a whole, and in particular how they interoperate with one another when it comes to traditional financial services providers who are engaging in crypto asset activity. And this is one of the things that if you look at some recent publications also from the BIS. So there was a publication yesterday, which unfortunately didn't make it into the slides here, that looks at regulatory comparisons on stable coins. That aspect of the strength of regulatory cooperation is one of the things that the BIS is looking at, particularly where there are potential lessons to be learned, not only within Europe, but also potentially also for non-EU jurisdictions who may want to emulate some of the things that are happening in the EU or vice versa. So there's still a lot of work to be done in terms of moving to that regulatory state. If we flip over to ESMA, ESMA has a ESMA has a very important role to play. ESMA is already a direct supervisor for a number of traditional financial services firms and financial market infrastructure providers. Under MiCA, ESMA does get the role of running a register of crypto asset white papers, including for issuers of asset reference tokens and e-money tokens. ESMA already runs a number of registers, so that's of course makes sense to add an additional register to ESMA's role of registers. One of the aspects, of course, is that the question as to whether private non-public sector data repositories have a potential role to play an additional add-on value. Currently, the MiCA is silent on that. There are potentials to do even more if you allow the private sector to also support the public sector's efforts on providing greater clarity and also, more importantly, perhaps comparability. Because the registers, if they're holding white papers for multiple asset reference tokens or e-money tokens, a savvy investor, an investor that wants to be informed and wants to make a prudent choice as to what crypto asset they're going to buy, if they log on to ESMA's website with the registers, they don't have the ability to compare crypto asset white paper 1 with crypto asset white paper 2. That's a big problem, right? If you think about it, if you're trying to educate investors, if you're trying to bring them into this new regulatory reality and give them comfort of making the right choices, the public sector is trying to do a good thing, but that lack of comparability not being offered there raises the question as to, can a private sector participant enter that role? And if yes, with what liability attached to it, right? So this is also something that is, I think, still needs to be answered. So the other thing, I think, just to wrap things up, the other aspect that I think is still open as we now are on this road to full regulatory reality of MiCA is that we do have transitional grandfathering measures that still apply. There is a move that has been published even last year to remind everyone in the market to please get their applications ready so that we can move to this regulatory reality by 30th of June. However, there are certain grandfathering aspects that will apply, and it really will be important for crypto asset market participants, regardless of how they're regulated, to be absolutely clear under what rules they are conducting certain activity if they're making use of a transitional or grandfathering measure. And that's an aspect which I think still needs to be addressed. And it's also one when it comes to looking at existing EMI license holders or those that are currently in the context of a potential future stablecoin looking to become licensed as an EMI, licensed as an EMI, that they will have to be very clear to say, this is what our license is. Our license may change over time. This is what we're permitted to do. You should consult your own professional advisors before making any investment. Now, I appreciate all of that is usually in the small print that no one really reads from an investor perspective, okay? Which comes to the point that regardless of what you do with crypto assets, buyer beware, right? But the onus will fall upon the regulated firm to ensure that it's educating its clients. Not just putting disclosures and disclaimers, but really going and educating. And that's an area which MiCA unfortunately does not currently address, but thankfully there's a whole financial education dossier at DG FISMA that potentially will be expanded to that. So thank you for your patience. I appreciate I've rambled on. I've covered a lot in a very short period of time. And unfortunately, it's very complicated, but with that, thankfully, Martin's going to talk about all the other stuff that is potentially equally as complicated, but somewhat different. But I don't know if there are any questions or anything on that.